Hello again everyone, mayong buntag, magandang umaga, mayong gabi, magandang gabi. This time we will be talking about the landmark case of Javellana versus Executive Secretary, also known as the Ratification Cases. But before we go into Javellana, we should first discuss the plebiscite cases. The plebiscite cases and the ratification cases actually go hand in hand. You can't discuss the ratification cases without understanding first what happened in the plebiscite cases. So, the plebiscite cases are all about Presidential Decree number 73 or PD 73. Then President Marcos, through this presidential decree, submitted to the Filipino people the ratification or rejection, in other words, a plebiscite, of the constitution proposed by the Constitutional Convention of 1971. This constitution would later on become the 1973 Constitution. In the plebiscite cases, the petitioners there argued that the calling of a plebiscite is lodged exclusively in Congress. They also argued that there was no proper submission of the proposed constitution for ratification because there was no freedom of speech, press, and assembly at that time, and no sufficient time to inform the people of the contents of the proposed constitution. However, while the case was pending before the Supreme Court, Presidential Proclamation 1102 was issued. This announced the ratification by the Filipino people of the proposed constitution. Because Presidential Proclamation 1102 or PP 1102 was issued, this led to the dismissal of the plebiscite cases because they became moot and academic. Specifically, insofar as PD number 73 was concerned, 6 justices were of the opinion that the case had become moot and academic, therefore the case was dismissed. And insofar as PP 1102 was concerned, 7 justices were of the opinion that the validity of Presidential Proclamation 1102 was not properly raised before the court, and therefore it was dismissed. And so now we go into the meat of the ratification cases, or the ratification cases themselves. The main case was filed by petitioner Javellana. The petition was filed to restrain respondents led by the executive secretary from implementing any of the provisions of the proposed constitution not found in the present constitution. So, to be clear, at that time, the proposed constitution was the 1973 Constitution, and the present Constitution was the 1935 Constitution, which was the Commonwealth Constitution. It should be pointed out also that the points discussed here later on are based on the opinion of Chief Justice Concepcion. This is because he wanted to express his personal opinion or to publish his personal opinion before summarizing how all the other justices voted in this case. Actually, they agreed that each justice would write his or her own opinion, and Chief Justice Concepcion published his opinion in this case, and then at the end summarized how the other justices voted based on the opinions that they have written themselves separately. And also, it should be noted that what is being assailed here is Presidential Proclamation 1102, which declared the ratification of the proposed constitution, and not the proposed constitution itself. So, what were the arguments raised by petitioner and respondent in the ratification cases? So, basically, the petitioners argued that there was no actual plebiscite held, that the citizens' assemblies, which were supposedly called and assembled, were not equivalent to a plebiscite or election required by the 1935 Constitution, and that persons disqualified to vote participated in the citizens' assemblies. And finally, that the conduct of the proceedings in the citizens' assemblies was not supervised by the Commission on Elections as required by the provisions of the 1935 Constitution. For their part, the respondents' main argument to counter the claims advanced by the petitioners was that they were raising a political question, which was beyond the sphere of the Supreme Court or not within the jurisdiction of the Supreme Court. So, in deciding this case, the Supreme Court, or through the published decision of Chief Justice Concepcion, identified the following issues. Is the validity of PP number 1102 a justiciable question? That was the first issue. The second was, has the Constitution proposed by the 1971 Constitutional Convention been ratified validly, given the applicable constitutional and statutory provisions? Third, has the proposed Constitution been acquiesced in by the people? And fourth, is the proposed Constitution now in force? In resolving the first issue, Chief Justice Concepcion said that the validity of the presidential proclamation is not a political question. In other words, he said, it is justiciable because under the separation of powers, a branch of government is only supreme within its own sphere. If it goes beyond the area allocated to it by the Constitution, the court has the power to pass upon such question as to whether or not it exceeded its power. The 1935 Constitution prescribes the method for its amendment or total revision. Therefore, whether or not the revised Constitution has been ratified in accordance with Article 15 of the 1935 Constitution can be looked into by the court. Second, was the new Constitution ratified in accordance with the provisions of the 1935 Constitution? Well, according to Chief Justice Concepcion, it was not. In the citizen assemblies, those 18 years old or over were allowed to vote. And this was based on the revised Barrio Charter, from which the citizen assemblies were allowed to be formed. However, under the 1935 Constitution, only those who are 21 years old or over have the right to vote. So we are now facing a conflict. We now have a conflict between a constitutional provision and a statute, which is the revised Barrio Charter. And of course, we all know that this conflict between a constitutional provision and a statute must be resolved in favor of the former and not the latter. In other words, the constitutional provision must prevail. Third, did the people acquiesce to the new Constitution? Well, according to the Chief Justice, it cannot be shown that a majority of the people have acquiesced to the new Constitution. He noted that it was a matter of judicial knowledge that no such assemblies in many parts of Metro Manila were held. And he concluded that if this was the case in the capital, in Metro Manila and its quote-unquote suburbs, how much more in the provinces, how much more in the far-flung areas of the country? He also opined that the people's inaction cannot be considered acquiescence because martial law was in force at that time. Inaction cannot be easily equated to acquiescence because there was then an atmosphere of intimidation and repression, which could have easily been the reason why many did not protest. There was likewise a claim that there was acquiescence by the organs of government, specifically the many agencies of government, most of which already operated under the new Constitution. However, according to the Chief Justice, this was not acquiescence to the new Constitution because they can be considered to have merely obeyed the President. These agencies are under the executive department. Therefore, they are bound to obey to obey the president because they are under the absolute control of the head of the executive department, which is the president. So the their obedience is not to the new constitution, but to the president who derives his power from the 1935 constitution. That was the conclusion of the court. Now, as to whether or not the new constitution was in force, there were not enough votes to say that it was not, or that it is not in force. The court, given the rules during that time, needed a majority of 6 justices to invalidate the presidential proclamation and say that the new constitution is not in force. However, 4 voted that it was in force, 2 voted that it was not, and 4 did not vote at all. Ultimately, 6 justices voted to dismiss the petitions. And in the end, the court declared that there was no further judicial obstacle to the new constitution being considered in force and in effect. And that's it. Daghang salamat. Again, thank you for watching or listening to Digest Tube. We hope you enjoyed this discussion. If you did, please hit like and subscribe to this channel for updates on our ever-increasing content. If you want to request us to digest a specific case, let us know in the comment section below, and we will try to do them as soon as we are able. Thank you, and good luck.